to give me advice.
Well, Commissioner, I believe that provision was linked to you all sitting as an appellate body, and it was to give you independent legal advice, because Port Legal Counsel's role at that point would be to assist the court in defending its SEPA decision. And so if the court was then sitting as an appellate body, it would then have the opportunity to get its own legal advice, because she was theoretically an advocate for the court's position on that SEPA appeal. So I think that that went by the wayside when having the court sit as an appellate body went by the wayside. And I don't know that there's as much of a need from at least my perspective to have outside independent legal advice if you aren't considering the SEPA appeals.
So from an ethical and conflicts perspective, that's required if you want to sit as an appellate body. As court's legal counsel, I advise the court and represent the court as the entity, and then I advise the commission. That in and of itself doesn't ordinarily present a conflict, but where you're going to have quasi-judicial authority, you have to receive independent legal advice. And so the provision that was there was to provide you with your own attorney for the purpose of advising you on the appeal and the appeal procedures if you're sitting in appellate capacity, because I can't ethically do that for you. Certainly, I would be concerned if you thought you were being brushed aside or some other issue with how we were advising you as court counsel, which is a matter of grave concern if that's a concern.
I'm comfortable being candid about this. I recall when we sought outside attorney help, that individual was selected by the executive director. We had no voice in making that choice, and I was really not happy with the person who was giving us advice. I mean, I'm just telling you, that was my recollection of what happened.
Are you talking about me?
No.
Oh, okay.
Before you.
I'm talking about the person who was brought in and paid by the port to advise
to advise you. Okay. So there's a couple things. There's a policy about how, and it'd be okay if you're talking about me. I just hope you could take that offline and it could be tomorrow. But or not. We could do that here. There's a policy and a resolution that governs how the port retains legal counsel generally and how those things are selected, and so that's part of the policy update that's coming before you again. So there's, I think, an opportunity there to consider how counsel is selected and that's awarded. That would be the first thing. The second thing, I think that if it's an area of specialization or an issue where the commission would like some type of independent opinion to be provided, I think that you have the capacity to request that, and then we go through that resolution procedure to retain counsel for that purpose. So I think you have that ability if there's a specific concern. I'm not sure if that addresses your issue or not, Commissioner Varner.
Perhaps would.
May I have a question on that? So are you saying that as a commission, we could take a vote and just, like a 2-to-1 vote would be bringing in outside counsel if that's what we wanted to do at any point? In time, or did I misunderstand?
I think that would be a little bit broad. I currently sit in the position as a contract and appointment of the court's legal counsel. Okay. However, if there's an issue of specific concern for the commission or a particular matter, there is the capacity to contract for additional counsel. And so, long-winded way of saying, I think you could contract for an attorney to provide the commission with an opinion as to a certain issue or question at the vote of the majority of the commission, subject to the contract provisions. Does that make sense? Probably not.
Well, and there is a policy that talks about how the port as a whole, or in general, hires legal counsel. We are in the process of updating that, and all that will come before you. And if there's specific language you don't think is in there that addresses this issue, we'd be happy to put something in there and make sure it gets
I saw a hand raised here. Did you have a question, Sharon?
Well, again, earlier I mentioned that we worked on this extensively last time, and so some of us took the liberty of coming up with some alternative language, and I had addressed that one with just a very short paragraph that just says independent legal counsel. Port of Olympia commissioners will have the option, either as individuals or as a body, to retain attorneys of their choice for the purpose of independent legal counsel pertaining to SEPA-related issues that may come before the commission. And the only reason that would be in there is because, in fact, your job really is to be a proponent for projects. I think that's part of the SEPA position anyway, and part of even developing the SEPA policy is in terms of the port's role in putting forward projects. I'm not speaking that very clearly.
Certainly.
But you see what I'm getting at. So perhaps they say, well, one commissioner thinks, you know, I'm not clear where this is going and it might cause another problem, and they could seek outside advice, and it wouldn't be a conflict of interest issue per se, but it would be a different perspective. And that's what happened before in the time he was asking about it. But another former port attorney was brought in, and I think that's what he was uncomfortable with, was it was totally that perspective, rather than, say, an environmentalist perspective or something else like that. So I'd be glad to hand this off to you guys later if you want. I brought copies.
And I guess a couple thoughts. One is, I think as a port SEPA responsible official, I actually have a different role, and that is to look at the SEPA checklist that is given to me by the project proponent, and that would be the project manager or a business unit at the port, and to evaluate it pursuant to SEPA laws, regulations, and our port policy. So I do think that, at least in that role, I'm not necessarily an advocate for the project. I'm looking at it from the SEPA perspective. But I also think that if the commission won't be sitting as an appellate body, there's just a limited number of ways in which a SEPA issue would come before you, especially if we have this appellate process that's resolved ultimately by a hearing. And again, the commission's absolutely can consider that provision, hiring independent legal counsel. But I just think if you're not sitting in an appellate body, there's likely to be fewer instances where a SEPA legal issue will come up. Sorry, Commissioner.
Jan, what?
I agree that there would be fewer instances, but I believe that development of SEPA policy, which is happening right now, is one of those instances. And correct me if I'm wrong, but if there were to be an appeal, I believe that Heather may be the attorney for the respondent. Is that not correct, Heather?
Well, if the respondent in the appeal is going to be the port.
Yeah.
Right.
And
Would
so
you
I
the
would be
port's
attorney
Yeah.
for the
Right.
port,
Right.
the entity. But the port, the commissioners are part of the port governance structure, which is still part of the entity. So the entity issues the decision, and I defend the entity. So you're correct, I would be defending the port. In my current capacity, sitting here right now, I'm acting as general legal counsel to the port, advising on the development of policies and resolutions, which is another area that I provide information and assistance to the port. My job isn't to advocate for any particular project, other than if the port has gone through all of the policies and processes and procedures, and I don't mean to talk to everyone, I'm trying to maintain appropriate eye contact. If the port has gone through all the policies and procedures to the point where the project is before the commission, then part of my job is to do legal review to make sure it's compliant, and my ethical obligation would be to advise the commission or the staff member, the executive director, and the commission, if it's the commission's approval authority, to approve or not approve on the basis of compliance with those policies and procedures. So I can be super unpopular with everyone equally, in that I could recommend disapproval and have recommended disapproval of things that I didn't think complied with appropriate law, policy, or procedure. So I'm not sure if that helps explain kind of where I'm landing here, but my only caveat would be, I think that we get into a difficulty if you start treating commissioners as individual, personal folks seeking legal advice for port matters on an individual basis versus what you might do just in talking with your constituents and other folks. That would be my only concern about that.
My concern was more in a simplified way of, you have an attorney for the respondents, the same person who's making the rules that you play by. And in some instances, and we can probably point this out later on as we discuss SEPA policy, I think there are things that clearly would benefit the respondents in this policy that we would like to see changed in a way that would be more beneficial perhaps to the appellants.
Understand.
And also is accepted standard practice. So that's
Got it.
where I was going.
Well,
Thank you.
can I just run back and see if maybe the ones that are up here, we can sort of run through and see if you're okay with these, and then we can get back to the other issues on SEPA you might want to discuss. Okay. So this one, I'm assuming this is not a controversial one, having a SEPA responsible official respond in writing within 10 days.
I'm fine with 9 point.
I'm fine with it.
Commissioner Reinhardt?
Yeah.
Okay. And this one, again, this one allows administrative appeals of all board seat official determinations and FEIS documents. Again, allows them to go through the less expensive administrative appeals process rather than resort to judicial review in Superior Court. You okay with that, Commissioner? Okay.
I can count.
Okay. This one is maybe a little more discussion. This is the one that removes the provision that had the court sitting as an appellate body.
I'm with it too. That was my main sticking point on the last process. That's what we went through.
I can go with that.
Thanks. And the next one is, it changed extends the timeline to file and respond to a request for clarification, and it requires the hearing examiner to issue an order if they're denying a motion for reconsideration. Again, it's sort of just clarifying the process.
I'm fine. The only thing, my only concern is the number of days versus what's happening in our community versus what we're doing now. That's my
And ultimately, this gives more time for somebody to read a hearing examiner decision and say, I don't understand.
So this is just in the case of denying a motion for reconsideration.
Right, and again, as Heather said before, the language said, if you file a motion for reconsideration and the hearing examiner does nothing with it within 10 days, then it's deemed to be denied. That you all presume that they.
Right, that's what this change is.
Yeah, so this is what it was before, and all this does is say, no, that could be too confusing, and so this requires the hearing examiner to actually issue a written order that says, I'm denying this motion. That's the only.
Well, and the other change was it took the timeline and made the timeline for requesting clarification the same as the timeline for request for reconsideration. So it had been shorter, and it took them both to 10 days instead of the 3 and 5 day provisions we had in the clarification.
So it gives people more time to request clarification if they don't think the hearing examiner was clear, or that the hearing examiner might have made a mistake. And then it also makes it clear when they deny the motion for reconsideration, and that triggers a judicial appeal period.
Well, let me ask for clarification on that first sentence. Extends the timeline to file and respond to a request for clarification. And there is not allowed any new information to be submitted.
That's correct.
You go on the record.
That's correct.
And yet, people who were in opposition to the project had other information that didn't get on the record, they're just out of luck.
Not necessarily.
Yeah.
Okay, we've got a comment on that too, if you're open to it. Are you ready to do that one?
Can I
Yeah.
weigh in just real quick,
Yeah.
because I'm sure you'll
Go
have
ahead.
a different perspective.
Yeah.
So the hearing examiner conducts an open record public hearing and hears evidence from individuals and takes documents and evidence and testimony. The conclusion of that hearing, there's an opportunity for the parties or the hearing examiner, based on if he or she needs additional information, to hold the record open for however long it takes for people to get that stuff together. So I know you didn't want to hear that, Commissioner McGregor, but so there's I should say there's three places where additional information can come in. First of all, if there's something that comes up that folks need an opportunity to respond to or submit additional information, they can request that the hearing examiner hold the record open at the conclusion of the hearing, and those types of requests are routinely and frequently granted. That's one. The second is that you can always move to supplement the record in addition to requesting reconsideration. That's not specifically addressed in the resolution. If you like, we can add that provision in. Normally, that's something that's in the hearing examiner specific rules of procedure, which in this resolution, you've delegated the authority to the hearing examiner to come up with, and then they have to come back to you for approval. And so my recommendation would be that we address those in the rules for procedure for the hearing examiner about how to bring a motion to supplement the record. And then the third place it can come in is if the appeal ends up in Superior Court and you're under the Land Use Petition Act for a project or a land use decision, then there's a process by which you can supplement the record with additional information. So there's 3 opportunities to get more things in than you had.
Let's say that could happen when you just noticed, you're just last comment. Let's say in the Tumwater, what's it called, master plan for the Newmarket Industrial Campus might raise the hackles on some neighboring property owner, and this would allow time for that process to be worked through and get information on that particular issue. By extending that, that'll be open, time available to gather information.
Well, not exactly. What the question is here is, at what point is the record closed so that the hearing examiner can make a decision? Because every time party A, let's assume it's an appellant, and we'll call, that's appellant, and we're respondent, right, as the court. Every time party A puts in something new, party B, and if you have multiple parties, let's say every property owner around Tumwater decided to appeal, you might have 20 parties to your appeal, in theory. Each one of them would then have the opportunity to respond to that new piece of information. So the idea is to at some point cut that off and then provide an opportunity for there to be supplements in the event that there's some legal basis to supplement, which they're specified in statute, and then they can be put in the hearing examiner role. It wouldn't allow for indefinite inclusion in the record, but there are means to do that while still providing a logical cutoff for your process, which is what we're trying to accomplish with this particular provision, is to say you can't use a request for reconsideration to bring in things that you should have brought to the hearing, or that you can request to supplement the record to include.
Just another thought on the sort of master planning process. I mean, hopefully during the master planning process, there's a whole lot of public engagement and feedback. So hopefully if there are issues that need to be addressed, we can address them in the master planning process. And it's only when we sort of have an idea of what we want the master plan to look like that we initiate the CEPA process. And we anticipate with a project that big, we'd be doing an environmental impact statement. So then there's all sorts of public engagement and process associated with that. And it's only at the end of both those processes, when we have an approved master plan from the commission and we have a final environmental impact statement, that we would ever end up in these appeal processes. So hopefully there's plenty of time to flesh out information and concerns from people.
Well, what I was contemplating was a possibility on that large project that the port would be promoting and pursuing, that one of the entities that was going to be part of our plan as an operating industry might have been kind of changed direction and doing something different than they were portrayed at the beginning.
Right.
And the citizens find these out, and they can't come in and say, hey, wait a minute, do you know what's going to happen as a result of company ABC coming in there? It's going to change, their whole direction has been changed, and now we're going to have DFE instead of ABC.
Right, and yeah, absolutely. There will be provisions for people who can bring that kind of information forward. Yes.
Well, right now, there's no, I don't disagree with you, Heather, on clarification. We're good on clarification. We have a couple of other issues, but on reconsideration, we raised before, and that, because of what happened during the Weyerhaeuser case years ago, where some, even though due diligence was done by the appellants, they couldn't uncover that information. And then when it was exposed, they'd lost their chance to appeal, and that was not fair. And I think everyone in this room, if they looked at that, would say, yeah, that was kind of unfair. So there is one little piece of language we would like to stick in there about, if it couldn't be discovered, you can enter new information if it couldn't have been discovered having done your due diligence and it's discovered later. So Jan's got that written out and can present that or hand it to you or talk about it, whatever. But
That can be submitted, and then we'll just take that under consideration at the time we deliver.
we have some others too when you're ready for us. Not too many, I promise.
And I think the last one was the the change to the climate change appendix and adding in biogenic carbon emissions and evaluation of those by the board in addition to carbon emissions. And I'm assuming Commissioner Morris is in favor.
Awesome. Carbon emission.
I think she's already.
Michelle, you were
I'm in favor.
requesting additional language?
That's right. That's right. I just want to make sure that these considerations are included when the study is done.
So the port will make that, do the evaluation, will be hiring someone to do the eval.
It would be hired out. Because this would be
Pretty technical.
following the Department of Ecology's guidelines. They currently don't include fossil carbon emissions, and I just want to make sure they do.
So do I.
Good. Yeah, it's an omission, and we're stuck ahead of
So
that.
we fix that omission.
Thank you.
Okay, so those are the ones we're hoping to get through.
I have one more though.
Okay.
And this might help with what I'm expecting on one issue, is in section 9.4.2 and 3 addresses the standard of review that the hearing examiner uses to decide appeals. And there's,
Number again?
I'm sorry, it's starting at the bottom of page 7.
Is this it here on the screen?
Yeah,
And it
it's
continues to page 8.
9.4.3.
Yep.
9.4.2,
Yes, 9.4.2 and 3 are the two sections that address this issue. And what, there's a different legal standard of review that applies to a threshold determination, which is the language you see, DNS, MDNS, that's a threshold determination, versus a final environmental impact study. It's a different legal standard. When we did the draft, we incorporated all the standards for threshold determination, and then also added the standard for the FEIS, which is the rule of reason standard, and that is not correct. And so what the recommended changes is shown on the screen. It's not in your copy, but what we would do is strike where it says the little sub I to little sub IV. We would make that 3 little i's, and that cures the problem with having included IV in the paragraph before.
And I can't see, did it get rule of reason in?
So you're
Rule
removing
of
the
reason,
ID?
rule of
Okay.
reason
You're
is
removing
in
4.
9.4.3.
Okay.
We're removing 4 and stopping it at 3, which would
Yeah.
then give your bases for, leave your threshold determination procedures correct, and then add the proper legal standard for FEIS.
Right.
where would I find written the rule of reason?
I can send you volumes if you'd like.
It's, unfortunately, it's
case
not
law.
a written rule.
Yeah.
It's something that courts have sort of evolved as they have made decisions over time about what the rule is.
I do have a desk book summary I'm happy to share with you that explains the case law development of it, but it's,
Maybe more than I want.
Yes.
if you have sleeping issues, it's recommended.
Insomnia?
So that was the only other
And there were,
substantive, other than business day, which Commissioner McGregor pointed out.
Yeah, and there were, these aren't substantive, but these, we got some feedback following the publication of the commission packet for this, from members of the audience. And so I've gone through and made some changes to a draft, and they're highlighted in green. And they correctly noted that once the responsible official makes an evaluation, before the entity, the port, commits to a final course of action, we have to, basically it says you have to finish the SEPA process. And so we had said the responsible official would commit to a particular course of action. It's actually, that's not quite correct. It's the port that would commit to the final course of action. So it's another way of saying you won't actually start working on your project before you finished your SEPA process. It's ultimately what that clarification goes to. And then the second one is just for grammatical purposes, making sure that we've matched up our tenses when we made the initial edit there. So those will likely appear in the next draft that comes to you unless you have objections to that language.
I'm okay with that language.
Alex, wasn't there one more about sometimes weekend, some things occurred on if the, you know what I'm trying to say, if the appeal occurs, the end of the appeal date occurs during the weekend, it should be the next Monday. There were some places that wasn't in there. Did you
Right, and I
take
think
care
you're
of
gonna
that
go
just
back and
easily?
double check the business day and make sure
Yeah.
that we've got that
Can
correct.
I just email, is that, I can't even read
I
that.
can email and mail, I can.
I just just whenever it's mail, it would be nice to have it email and mail, or, you know, just not email. I'm not sure if that's there, I can't even read it.
I can't read it from
Maybe,
here.
but just in general, when it's, if it's just email, it'd be nice if it would be email and mail throughout the document.
Sure, yeah, we definitely don't want to exclude the possibility of people.
We don't have those computers.
Okay, so those were, I think, the last, wait, sorry, I think there may be one more, I apologize. This was in 9 point.
This is in 9 point, hold on, 9
I have it in my note.
9.5.2, sub 1D on page 10, middle of page 10.
And I think I tried to be helpful and make an edit that clarified, basically, yeah. And I think what happened is I ended up confusing things even more, because ultimately what you want to have is a date certain, because what we're talking about here is having a final decision come from the hearing examiner. And you really want that to be a date certain, because that is the time that triggers your judicial appeal period in court. Boy, if you miss your appeal period, you're out of luck. I mean, you lose your right to appeal. So we wanted to make sure that whatever we put in here ended up in a date certain, and the language that was in there before didn't. So this is a way of making sure, I think hopefully we keep the same idea, that, what was the idea here?
The idea,
That the time didn't count.
Yes.
The time didn't
Yes.
count, the tolling.
Yeah. And so this language hopefully will resolve that. So this should also appear in the next draft that you'll see before you. And again, it's just to clarify the issue and just make sure we have a date certain that triggers the judicial appeal period start. Okay, so I will.
Okay with that.
are you okay with that?
I'm okay with that.
Okay.
Okay, I will relinquish.
But I do have a couple of things to talk about.
Sure.
If it's time.
Absolutely.
A couple of changes, actually. I'd like to get all the changes in agreement now so that the next draft is pretty darn close to final if we could. If we could look at 9.5.2, and this is a really simple little change. In that sentence, it's a long sentence of clarification and/or a motion for
On page
reconsideration.
9 or?
Page 8 of the final, of the cleaned up draft.
And slash
And or.
before or, to make
Right.
clear you can do both,
Yes,
understood.
thank you.
Where?
9.5.2, request for clarification or reconsideration of hearing examiner decision. Any party may submit either a request for clarification and/or a motion for reconsideration, rather than just or.
So what I'd like to do, if it's okay with you, is include that in the title too, put and or
Oh,
in the
yes.
title and then and or in that sentence, if that's okay?
thanks. That is okay. And then, just for clarification, I don't understand, in 9.5.2 sub IA, right in the middle of that long paragraph, what is Port of Olympia proprietary type user charges for port goods and services for resolution in effect?
It's the schedule of rates and charges that the Port Commission adopts every year with the budget.
Okay.
And it sets things like, I think, wharfage, and, I mean, there's a whole.
All the
suite.
fees.
All the fees.
Okay,
all the
great.
fees and
The
charges.
port equivalent of your fee resolution that would be adopted by a county commission or a city council.
Okay, my ignorance, sorry.
No?
Okay. And then, one other question in that same paragraph, very towards the end, second to the last sentence. The sentence begins, within 5 calendar days of filing the request for clarification, a party may file a response to the request for clarification without direction or request from the hearing examiner. Does that mean that that would be an additional action, and what does that look like?
So ordinarily, a party files a request for clarification, and we believe we have the same language that appears in both clarification and reconsideration.
Okay,
So clarification is one purpose and reconsideration is another, right? So the intent there is party A, who wants it clarified, files that motion for clarification. The hearing examiner doesn't have to issue an order saying,
okay,
court, please respond.
okay.
Instead, you can file a response if you do it by that day without having the hearing examiner direct you to respond. It gives you that response out of right. The same would be true if the court requests clarification, and then the right would go to the appellant to respond to that. So every time in a situation like this that somebody gets to say something, somebody else gets to say something back.
Absolutely, and that would expedite the process and not drag it out to 45 days probably,
Well,
possibly,
It's accounted for within that period.
or 120 days, possibly,
Possibly.
hopefully. And then,
May I make a comment?
yes,
please? Regarding the issue of clarification, clarification is asking for the hearing examiner's clarification of his decision. I don't care what the respondent says, I want to know what the hearing examiner says. So in my opinion, all of that could be struck. I don't think that there need to be responses from other parties. If I'm an appellant, including myself, what I'm simply doing is asking the hearing examiner to please clarify something that he wrote in his decision. If we get into what's written in the policy right now, we're having respondents and appellants trying to decide what the hearing examiner meant. And that isn't what I would want. I would want the hearing examiner to say what he meant for the record. So I can understand that being there in a request for reconsideration, but I don't understand it in a request for clarification. And as I was studying the the policies of other entities like City of Seattle, all of the others, they didn't include that in the clarification, although they did in the reconsideration.
because really you get other people interpreting the hearing examiner, she said, and that's the hearing examiner's job to write back what he or she meant.
Correct. And so all we're really doing is providing there's a wide range of things that could be clarified. I mean, everything from a fairly routine, you meant to say.
Right, but that's the hearing examiner's job to say.
In which case, other party might not file anything. But if the question, you don't have to file a response to request for reclarification. This grants the right of someone to respond.
But why should anybody have that right, is what my point would be, is because I don't need that right. I mean, in fact, you would be mad at me if I started trying to sneak in more arguments and using that as an excuse to get some information in. And saying,
Completely agree, and you shouldn't be doing that. I think sometimes requests for clarification are made and they're not a clarifying question. And so in fairness and equity to both sides of the principle, I think it's okay to provide an opportunity for the non-moving party to respond and say, I don't think this, for example, this is outside the scope of a request for clarification because this is the standard for clarification.
Okay, that's a different sort of thing. I see.
As opposed to I think the sky is blue versus not. So I think there's a limited place for it, but wherever there's an opportunity for one person to make a motion as a practical matter, if there was a motion and then the other party requested that the hearing examiner allow response, 99.99% of the time they would grant it. And so this just provides that automatic ability for either side, appellant or respondent. That's all.
Yeah, I just want to say, as an attorney, I agree with Port Counsel. You know, some requests for clarification are actually an attempt at additional argument, and the other party, whether it's the respondent or the appellant, should have to say, I'm sorry, it's clear to me. And then the hearing examiner can look at both sides and issue his clarification.
That makes sense. I've just seen it done the other way, where somebody just found a way to sneak in more argument.
Trust me, I'm trying to not have that occur.
I know.
so everything is great the way it is.
Okay, thank you.
Sharon, did you have a comment?
Yeah, 9.4.3, standard of review, page 8. What came out, well, let me just explain something. It's important to have the hearing examiner, in my opinion, provide an analysis so that anyone who is considering an appeal or even a clarification or reconsideration request can see whether the hearing examiner misunderstood some testimony, misrepresented that testimony, misapplied the law, whatever. The only way to know if the hearing examiner provides that information, in other words, his or her sort of train of thought or reasoning. So what was deleted before said, the hearing examiner shall render a written recommendation to the Port Commission containing 1, an analysis of why they rejected the accepted threshold determination or deemed the FICE adequate, and I would add the words or inadequate. 2, a synopsis of the testimony and arguments presented. And 3, the hearing examiner's finding of facts and conclusion of law. I think that's just important to have in there. It's no biggie. It doesn't change. It's not pro or con anybody. It's just that anybody then has, we've made clear to the hearing examiner what's needed in a final decision so that everybody agrees and it's going to be clear there. And then people can see it, and I don't think it's a big deal, but I think it's important to get it in there. I don't think it causes any problems for anybody, and so I've written that back out for people.
And I would just, I think that's fine, if you want to put that in, that's fine, it clarifies what the hearing examiner needs to include. But this was pulled out because this was talking specifically about the hearing examiner giving a recommendation to the commission, and then you would ultimately make the decision. We've decided that's not gonna happen.
Right.
So we could just change the language to say the hearing examiner shall render a written decision containing.
Stop. Wait. So what I'd like to do is, if you want to add that back into and be more specific about what the hearing examiner includes beyond findings of fact and conclusions of law, then I'd want to put that back in paragraph 9.5.1, which talks about final decision and defines what that is.
That's fine too. Yeah.
Is that okay?
Sure.
I'm okay with that.
That'd be great.
Fine.
And I think that only spoke to FEIS, and so I would recommend we make it a uniform standard for all decisions of the hearing examiner. If that's okay?
Yes.
Okay,
It's okay
great.
with me.
Sue?
Yeah, I have some simple ones, and where it precedes some of these. So one is 9.4.2, and it's just a clarification or a further definition. At the end, so we're on page 7. Just a sec, I have to get to 7. At the end of the paragraph, I would like to remove threshold determination subject to appeal is, and put in further what it is a further definition of what a threshold determination is. I'd like to add in administrative findings, inferences, conclusions, or decisions made by the responsible official are. I can give it to you.
I don't understand what that change is for.
It's just clarifying what is to be considered. Rather than threshold determination, it's a further definition of threshold determination.
Is this one we can keep?
Yeah, oh, wait.
Or no? Oh, you have notes on that one here. Yeah, I didn't see it.
It's okay. So, it's just more definitive is what it is.
Is a threshold determination a confusing or not clear term?
No, it's that
I thought it was
it's that the reversal would be based on, reversal of the decision will be based on whether or not the responsible official made some boo-boos in the following areas. So it's not as broad as just saying the threshold determination was erroneous or something, but rather some of the conclusions were or whatever. So it kind of narrows the scope a little bit, but it makes it, well wait, broadens the scope I guess a little bit. I'm not sure what I'm saying there, I'm sorry. But what it makes it seem to me is it allows for more flexibility in a hearing examiner's decision and deciding that maybe the entire decision wasn't wrong, but this was erroneous, and so that's one aspect of it.
So the problem is a technical matter, that the threshold determination is a term of art, and it is the DNS, the DNS, the MDNS, or the DS, that is the threshold determination is defined under statute and rule. That determination is what is subject to appeal. The determination itself can have some, all, or none of the characteristics just in this proposed language. It has to follow the format specified in the WAC and adopted by reference elsewhere in the resolution. but it doesn't have to contain these elements. And so my concern in the suggested language is it broadens, you're looking at things other than what's being appealed potentially, when what's being appealed is the threshold determination. What would come out of an appeal of the threshold determination presumably is you have to show that it wasn't clearly erroneous, and that means that the court would have to demonstrate procedural compliance with SEPA as well as substantive compliance with SEPA, which then gets to some of these other issues. But I would, as counsel, I'd recommend against accepting this, broadening the definition of what's subject to the hearing examiner's decision beyond the term threshold determination or FEIS as the technical terms.
And this is why, this is where attorneys disagree. This is why I would think this is one of those times where, because this was word for word by Gerald Steele, a noted environmental attorney who said this is, and said it was important. So that's why looking at another attorney sometimes might be, I'm not going to fight about this, I'm just saying that's another reason for having another person to refer to, because people, I mean, Heather and Gerald got into it a few times, and in that time, it's what noted attorneys do, it's what they do all the time.
Subject to the will of the commission, but I'm happy to call Gerald and walk through where this is coming from and see if there's language that can address my concerns,
nice.
that also addresses your concerns.
That'd
I'm
be great.
happy
Thank
to
you.
do that,
Thank
if
you.
that's something the commission would care for me to do.
That would be
Well,
helpful.
I'm inclined to leave the verbiage as it is, but that's
Can I-
up to you, commissioners, whatever you want to do.
I'm fine with the language the way it was presented,
Yeah.
like Heather's presented.
On this sheet, the other one is important. We caught it at the end of July, but on 9.4.6, we would like to add at the end of that section.
What page is that?
Okay, on page 8, under conduct of proceedings, it's at the bottom of the page, after the last word, add all decisions, recommendations, and orders of the hearing examiner will include a list of all parties of record and their mail and mail addresses. Because he's had one thrown out where the list was not identified, and so if the hearing examiner identifies it, then we know where to sit it at, and we don't want it thrown out on this procedural error.
I'd like to see that included in our
Can I put it in 9.5.1,
9.5.1.
which speaks to the content of the final decision of the hearing examiner?
I'm not a lawyer, so
Wait a minute.
Because the 9.5.1 says what the final decision is and who it gets mailed to, and so I'd like to put this language
Okay.
specifying parties of record in that same, where we're adding the other language about what he's making findings on, I'd like to put it all in 9.5.1.
Good.
And am I just blind? I could never find a definition of parties of record in here.
Well, I think I thought it was generally understood that it's a party that's appeared in the, like, filed an appearance in the case.
What about testified or anything like that? It's simply people who've just filed.
Well,
Yeah.
yes, in a SEPA appeal,
Okay.
to be a party of record, you have to file an appeal, as opposed to a more participatory thing like you're here today, right? You sign in on the sign-in sheet, you're not a party of record to anything, it's different.
But if she spoke, she is?
No,
If you
not
speak-
in,
oh, okay.
not in a SEPA appeal, because SEPA appeal has standing and other requirements.
Okay, thanks.
Now, throughout the document, he had many places where he would say the list in email and mail, and it's been captured by Jan in one of her statements, but it's not captured here. But there are other places where you might put it in, where you say mail and email to the list.
Yeah,
If you don't take on what Jan recommends, then there are other places, and you'll see it in our 731 recommendation where he says mail and email. It's already in there in, well, I don't know, one color.
Good with that?
Sure.
Thank you.
Commission's okay with that?
Yeah.
Okay,
Go for it.
Okay, yeah.
Thank you.
Yay. There's a question, George. Jim.
Yeah, I have a couple of issues that I'd like to bring up, and I'm not sure when to bring them up now. Okay,
Please.
Get this done.
Regarding clarification and reconsideration, I have a copy of changes that I think would be appropriate, or that I would.
9.5.2.
The one that I specifically, some of these we've already discussed, but the one specifically that I'm concerned about is on the second page of this document, where we're talking about motions of reconsideration will be based on the following grounds.
Yeah.
And the court specifically states that discovery of new evidence will not be allowed as grounds. That's a very unusual clause. I have here an example of City of Seattle, for instance. Newly discovered evidence of a material nature which could not with reasonable diligence have been produced at the hearing is a common grounds for reconsideration, and a very important one. This is the information from Seattle.
It's in blue.
Yeah, this is very difficult to look at this.
Yeah, what I added is in blue and underlined.
Okay,
What I deleted is in red and crossed out.
thank you.
There is some yellow there that was added to the court copy that I got that I believe is one of the commissioner's additions.
That was Alex's or anything.
Maybe this will help. I don't have any, from the legal perspective, advising the commission. I have no objection to the inclusion of this additional grounds and then modification of the remaining language to allow for this. I do think that there should be a follow-on sentence, which I'd have to look at, and I can speak to whomever about that too, that talks about the kind of proof required to show that it was in fact newly discovered. So some kind of declaration or something about why it was it couldn't be presented at the hearing. So it should be supported by some type of documentation. Sure. But if the commission's okay with that change, as counsel, I have no objection to there's no legal reason not to do that.
One up here, I had a couple more things. We were talking about service. There have been problems before in service to the Port of Olympia. In one instance that I can think of, there was nobody available at the port to receive service. So I'm wondering about a clause that would simply say that the Port of Olympia will assure that there is always a port person available during regular business hours to receive legal service on behalf of a port official or the Port of Olympia department.
As a result, when there was an intern or something who took a document and was considered not to be a port employee?
Yeah, it ended up being a rather extended legal argument, but the intern was the only one available at the Port of Olympia at the time the service was given. There was nobody else in the office. Nick Handy had gone home, and there was nobody to serve. So the person who was served was the person at the main office who, unbeknownst to us, ended up being an intern, and it was found to be not a proper service. I'm just asking that the port commit to always having somebody present, and that somehow be indicated here.
So service of process on the public entity is governed by statute and rules of civil procedure.
Right.
And so I would be loath to tread on those waters as part of your SEPA policy resolution. I do think as a matter of port policy generally as part of the update, we do have legal policies, and I think that that language could be addressed, because that should be the case for litigation or service matters against the port regardless of SEPA or otherwise.
We can identify certain hours between 9 and 3, so there wouldn't be somebody there after 3 o'clock that would be taking it, had to be turned in so that there's somebody in the office during these certain hours. Couldn't we identify a window between 9 and 3?
Normally it's during regular business operating hours of the entity. I guess what I'm saying is rather than put that in here, I think that's something that applies more broadly than just in SEPA. It applies to litigation against the port generally. Okay. And so I think if it's not already addressed, which I can't speak to because I don't know all the policies off the top of my head, I'd like to address that elsewhere in the port's policies regarding service of process and acceptance of process, if that's
Okay.
okay. Your other case precedes my time, so I can't
Yeah.
speak to those.
Except that this one says all through, this SEPA policy says must be served to, it's your position, what is it, environmental?
Yeah, director, I think.
Or Port Environmental Department or something, I don't even know if it says director. But so you could come in at 4 PM, you're gone, there's nobody else around. So somehow that needs to be adjusted, I think adjusted in the SEPA policy then, Heather, because what if Alex has gone on vacation, you know, and she hasn't designated somebody else to receive it? We gotta have a staff member to give it to, we just gotta.
Yeah, that's the initial filing of the appeal. So let's look at if we need to clarify that
Yeah,
part of it,
that'd be
but
great.
I wouldn't want to get into broader services.
No, that's
Yeah.
fine, just so you can get
And I
that.
will need to go on vacation
And
period.
it
Yes.
would seem to me that,
Just say-
That's it, you got no more
a
business.
server would have checked to see if they were serving to somebody that was appropriate.
It wasn't an experienced server. That
Okay,
was
so I
problem
mean,
number one.
I'm astonished that a server would do that.
No,
To me,
right,
that's
but-
the person that is
Well,
actually
most
at
people
fault.
here
Usually
can't
it's
afford,
us.
yeah, most people can't afford a server, that's cost money. So you go in, you say, can you sign for this? They sign for it. You assume they're telling the truth, and that's what happened,
Well,
so.
they probably were telling the
Yeah,
truth.
they thought they could. Yeah.
Right.
Yeah,
They thought they could receive it.
Yeah,
Right.
exactly.
But they
And
weren't.
so how would we know, you know? Who
So,
would know?
okay.
Okay,
Any more, oh, I'm sorry.
Yeah, I had a couple other questions. In this copy that I just gave you of request for clarification, I did add by mail or email on the list in the decision in 9.5.21A. That's in blue, and I think we've already discussed that. We've already discussed that you would prefer to keep the response in the clarification. I had a question about in B, a hearing examiner decision on a request for clarification is a final decision and is not subject to a motion for reconsideration or further clarification. It's rather unclear. If a hearing examiner acts on a request for clarification, that could clarify somebody, that could make something that could make somebody think, well, I am going to go ahead and file a request for reconsideration. So I think it would be better to say a hearing examiner action on a request for clarification is not subject to a motion for reconsideration or further clarification.
Right.
In other words, the clarification, you can't start the reconsideration process again.